All rise. The Arizona Court of Appeals, Division 1 is now in session.
Please be seated. All right, we're on the record now in case CR13 895, State of Arizona versus Jeffrey Richard Martinson. This is the time set for oral argument. And for appellants, I know we have counsel for the state and also counsel for the victims. I'm sorry. So who do I have for the state?
Jerry Grant.
Mr. Grant.
County Attorney for the state.
And then for the
Paul
victims?
Cassell from the University of Utah Appellate Clinic.
Mr. Cassell. Okay.
And Colleen Clace with me, and she is from Arizona Voice for Crime Victims.
Okay. And then for appellee defendant, Ms. Van Drummel?
Yes.
Okay. Now, we've given extended time for oral argument here. Each side has 30 minutes. A couple of issues I'll just address up front. Well, let me address it in this fashion. Divide up the time the way you see fit. I know that there's two parties over here, or excuse me, there's two different groups of lawyers for the appellants. However you want to divide that time up, it's up to you. And however you want to set aside some time for rebuttal, it's up to you. But there is a cross appeal here too, so Ms. Van Drummel, if there's an issue that you want to, that you think was raised in a rebuttal argument by the state or the victims' counsel that applies to your cross appeal, I don't know that you can anticipate reserving that time now. Let us know, and we would probably consider giving you a little bit of extra time to address it. Fair enough?
Thank you.
Okay, a couple of things. We've certainly read everything in this case. We've discussed the case. We're very familiar with the issues. So keep that in mind as you present your arguments today. These arguments are audio and video recorded, and they'll be uploaded to our Court of Appeals website in a couple of days. So I want you to keep that in mind as you make your arguments. As I stated, each side has 30 minutes to present their arguments. There's a clock on the podium in front of you to keep track of your time. And if you need to set aside some specific amount of time, either on cross appeal or rebuttal, just signal us on that before you sit down. So with that, counsel for appellant, Mr. Grant. And since we do have some different counsel involved here, if you would just announce who you are and who you're representing when you get to the podium.
Good afternoon. May it please the court. My name is Jerry Grant, Deputy County Attorney representing the state. The state here is asking the court to reverse the trial judge's order dismissing this first-degree murder case with prejudice based on a finding of intentional prosecutorial misconduct. Our position also is asking the court to reverse the judge's findings regarding the individual instances of conduct that the judge listed in her ruling. The case law is fairly clear from Arizona that dismissals with prejudice based on prosecutorial misconduct are the rare case. The bar is set very high for such a dismissal. And if you look at the cases, I think it's clear, I'm using the words I'm going to use in a moment, but I think the cases plainly state that the prosecutorial misconduct has to be clear and obvious. I think if you take a look at Minute, you get a good demonstration of that. There, the prosecutor knowingly presented testimony that was false to the jury in 2 trials. In Jorgensen, you have a prosecutor who, in the face of 6 defense experts who testified that the defendant was insane, the prosecution offered no counter-expert and instead engaged in what the court described as attempts to accuse the defense of fabricating the defense and of even buying the expert. In Poole, you have what the court, I believe it was in Poole, called a masterpiece of misconduct and attached an entire appendix listing the improper and prejudicial cross-examination that the prosecutor engaged with the defendant. Here, you don't have such plain and obvious conduct.
Does the issue of one's interpretation of the Stiers case, isn't that really a fundamental issue here?
The state disagrees with the trial court's interpretation. However, the state recognizes that it was a ruling that was made during trial and the prosecutors were bound to follow it. Either that or get it overturned, which did not happen. Just,
But doesn't
as I
that-
mentioned,
Doesn't
I'm
that
sorry.
bear on whether or to what degree that there was misconduct?
I don't, well, if you find that the court's ruling was clear and that the prosecutor clearly abused it, then, again, you have a binding ruling by the trial court that I believe the attorneys are required to follow. Counsel for the victim has a slightly different take on that from me, and I'll leave that to him. I would point out a couple of things with regards to Steyer. First, despite how the court portrayed it, there is no clear holding in Steyer's that applies here. The situation simply did not exist in Steyer that exists here. The child abuse, there was a child abuse as a predicate felony for felony murder in Steyer's. However, there was also a premeditated murder charge as well. And the problem in Steyer's that the court found, which led to the merging of the child abuse with the murder case, with the murder count, was that the only evidence of intent regarding the child abuse in Steyer's was intent to kill because the child was shot in the back of the head.
So is your distinction of Steyer's that, well, how would you distinguish it from this case?
I would say it simply doesn't apply. It doesn't stand for what the court says it stood for. It does not say if you charge child abuse as the predicate felony with an intent to injure, that you're limited to present only intent to injure testimony. That's how I don't know if I'm interpreting it, but I'm just saying that's not what it holds at all.
Is it the state's position that all of the intent evidence that was disputed at trial in this case would come in if the state had charged only child abuse?
The evidence that was excluded?
And that was disputed?
Okay.
Evidence of intent, evidence of...
Okay.
of,
I'm not sure I'm following the question. If you could ask me again?
What if there was only a child abuse count? There
Okay.
was no felony murder count. Could the state have presented evidence not only of intent to injure, but of intent to kill the child?
I would say so, yes. I think in general, the law, statutory law in Arizona is that the state can always prove more than what's charged. Proof of intentional conduct suffices to prove knowing conduct. Proof of knowing conduct will suffice to prove negligent or reckless conduct. Proof of the higher also satisfies the lower.
I think I interrupted you. You were, I think, going to draw some distinction between Poole, Minette, and Jorgensen in this case.
Yeah, just that the type of misconduct simply isn't the same. There's no clear and obvious misconduct here. And I think the analysis in the opening brief where I went through each individual act of misconduct that the court relied on demonstrates that in most cases there was no misconduct at all. And in many, if any of the other ones, it's at best ambiguous as to whether there was misconduct. The court's ruling on Steyer's basically set up a very difficult situation for the prosecution. The court recognized that the same evidence that showed intent to kill also showed intent to injure. So it was a little difficult for the prosecutors to present evidence of intent to injure without also, perhaps by implication, suggesting an intent to kill. I don't see any way the prosecution could get around that. And I think they complied with the order as best they could.
So are you saying that the evidence of intent to injure is the same evidence that would be presented for intent to kill?
Yes, I think it's the same evidence for both. One other point I wanted to make regarding the ruling is I think the ruling was arbitrary. The record shows that on at least 4 occasions, the trial court was presented with the same arguments regarding intentional prosecutorial misconduct during the trial and after the trial. And on all 4 occasions, the trial court denied relief on the claims of intentional prosecutorial misconduct. Our position is that without some additional event or misconduct that happened after that, changing the court's mind is simply arbitrary. It is not the type of ruling that should be upheld for dismissing a first-degree murder case with prejudice.
Well, it might not be arbitrary if on a complete hindsight look, where you have more in the picture and a bigger picture and more detail, not just little slices, you look and you see something that you didn't see before. That doesn't necessarily strike me as arbitrary.
Well, I would agree in abstract. But I think if you look at the record, this wasn't the trial court did rule at the very end. It was the exact same claims that were being made, and also the trial court commented throughout the trial on these same instances of what she felt were misconduct. She warned the prosecutor not to do that. There was nothing different at the end of the trial that occurred that justified what the trial court did in reversing itself. There were some mentions of what the prosecution did with respect to obtaining a new indictment. The state took a special action to this court at that time, and a different panel of this court ruled that the state had shown good cause to file a new indictment and to dismiss the old indictment. So I don't see how that could be any basis for the judge to change its mind regarding the ruling it had previously made.
I think, what do you say in terms of one of the findings by the trial judge was she concluded the state had sought to remove her as a judge and had sought to remove defense counsel, and that was an additional grounds upon which to find misconduct. What's your response to that?
As I pointed out in the brief, I think the court stretches to make that a basis for a finding of intentional prosecutorial misconduct. The court drew up basically a grid in which it listed what it felt were 7 instances in which the prosecution tried to remove them. As I explained in the opening brief, there were not 7 instances. The first instance that she listed was an oral motion. The judge's response was file something in writing, which the prosecution did. The court counts that as 2 instances when it's really only 1.
Is that important, though? So it's 6 efforts then.
Well,
what do you say about that?
And also in the opening brief, the next attempt to remove was the removal, I'm drawing a blank, not for cause, but the peremptory with the filing of the new indictment. They were filed in both cases, and again, the trial court counted the 2004 and the 2012. Again, the trial court counted them as 2 when it was only 1. Actually, let me correct myself. It was 1 that was filed. It was denied on the grounds of untimeliness. The state filed a motion to reconsider that finding of untimeliness. The court considered that motion to reconsider and the original motion as 2, which I think is only 1.
Mr.
And as
Grant,
for
let me just kind of interrupt you. So what is the overall point that you're trying to make in that regard? That I'm assuming you deny that the state tried to remove Judge Duncan.
Yes. No, I'm not denying that they tried to remove her. They did file those motions. I think that gets back to another point. I'm starting to get into a little bit of the time of counsel for the victim, but let me explain it. I think it goes back to one of the other post-trial findings that concerns the filing of the new indictment when the trial court felt that the prosecutor had lied to her about whether or not the previous indictment had been dismissed. I think if you look at the record, it makes no sense for a finding that the prosecutor lied to the trial court. The prosecutor would obtain no benefit by lying on such an obvious manner in open court, something that could be easily discovered, which it was, that the case had not been dismissed. All the prosecutor would benefit would be a bar complaint. I think the only rational explanation for what happened there is that there was a misunderstanding between the trial court and the prosecutor. Both parties there used the present tense when they were talking about dismissal of the old indictment. I think the trial judge's question was, is the indictment dismissed? The prosecutor's response was, yes, it is, I believe. And as the prosecutor explained later, when the judge discovered that it had not been dismissed, the prosecutor explained that there was essentially a practice in the trial court regarding dismissals when a new indictment is filed, where it is orally moved to dismiss the old indictment, basically on the grounds that now we have a duplicative indictment, and those were routinely granted. So I think the only rational explanation, since the prosecutor could not gain anything by lying, is that when the court asked, is the case dismissed, the prosecutor was hearing it as, is it being dismissed, essentially asking for dismissal. And when the prosecutor replied, yes, it is, I think she was saying, yes, we are asking for it to be dismissed. The two misinterpreted each other.
Do you think that the court, or is this part of your argument, or that the court should have considered lesser sanctions than dismissal with prejudice if it had, based on its conclusion, there was prosecutorial misconduct?
If the court finds there is, our position is that there was not prosecutorial misconduct. There definitely are other considerations, other sanctions that could be imposed, and those even include, which aren't judicial, but bar complaints, which it's my understanding have been filed. There's also, as the trial court pointed out in its finding, the prospect of getting a new set of prosecutors to handle the case, forcing the prosecutors to proceed on the 2004 indictment, and simply dismissal without prejudice. I'm sorry.
Let me just ask you one other question. This, have you read State v. Moore? That's the case where the predicate felony was first-degree burglary, where the felony that was intended was murder inside the home?
It's not coming to mind at the moment.
All right, then I'm not going to ask you about it.
Thank you. I'd like to save a little bit of time, both for counsel for the victim and possible rebuttal. Thank you.
Thank you.
May it please the court, Paul Cassell from the University of Utah Appellate Clinic, here representing the victim in this case, Ms. Chris Eberly. I know there have been some procedural objections raised from the defense about my right to be here today. In the interest of time, I'd be prepared to submit those issues on our brief unless there was some specific question that the court would like answered.
Why don't you go ahead and make your presentation?
All right, let me turn to the merits of the issue then, and the question becomes, were the victim's rights protected in this case? We're asking for the same relief as the state, but on different grounds. The victim's interests were not protected here. Under the Arizona Victims' Bill of Rights, all victims in Arizona are entitled to have the rules of criminal procedure construed to protect victims' rights throughout the process. Rule 16.6 of the Arizona Rules of Criminal Procedure are at the center of this case. They're in the title captions of the order that's at issue here. That rule was not interpreted to protect victims' rights. Instead, what the judge did was to select the most extreme sanction possible, dismissal of a first-degree murder indictment when there had already been an initial conviction, and did not consider other options. This is a strange case. Other cases that Your Honor was mentioning, such as Jorgensen and Minute, involve situations where prosecutors did not have enough evidence or were concealing evidence that would have torpedoed their case. In this situation, the trial court was trying to keep out additional evidence of guilt of the defendant, which puts this case on far different footing from anything else that's out there. And let me just turn to Judge Gould's question, or I'm sorry, Judge Gamel's question. I think you're exactly right. The elephant in the room here is, what about this ruling on the Stiers case? The Stiers ruling, to put it bluntly, is bizarre. The Stiers interpretation that the trial court came up with. What the trial court's...
I'm not sure it's bizarre, but why do you think it's bizarre?
Let me explain why. I'm a law professor trying to explain to my students what the trial court's interpretation is. And as I understand the interpretation, the defendant could be charged with first-degree murder if he premeditatedly killed a child. The defendant could be charged with first-degree murder if he intended to injure a child, and the child's death resulted.
Felony murder.
But if there's a situation where he acted with a more heinous mental state, he didn't want to just injure this child, he intended to kill the child, he can only be charged with second-degree murder, because he can't be charged with felony murder because that would collapse. And so you end up with what we have described in our briefs as a gap under Arizona law, which...
You're describing your understanding of the trial judge's ruling.
Correct. And recall, of course, Stiers is a case in which the issue, as Mr. Graham was explaining, was not even presented. It's a situation where what was at issue is whether at sentencing 2 counts collapsed. It's not a question of evidence, and rules of evidence in Arizona and elsewhere allow evidence to come in to show motive. Arizona Rule of Evidence 404B says you can put in other acts, so forcibly administering a drug to a child, that would probably injure him, but it may well also kill him. Those would be things where there would be overlapping motivations, and the evidence under Arizona Rules of Evidence ought to come in. The trial court, though, made a ruling saying, no, that can't come in, and that explains much of the alleged misconduct. Prosecutors are trying to adhere to a line that, frankly, makes no sense under the law, that doesn't take into account traditional rules of evidence, allowing additional evidence for motivation to come in. And so it's not surprising to see a considerable amount of misunderstanding during the trial. But let me now turn to Judge Gould.
What does that sentence in Stiers mean, then, if it doesn't mean what the trial judge said? Let me find it here.
Yeah, the first-degree murder statute, ARS 13-1105, not the child abuse statute, applies when a person intentionally kills a child.
That's it.
Right, and so the point to be made there is Section 1105 is the premeditated murder statute.
Yeah.
There's simply what I would call a typographical error in that sentence. The court meant to use the word premeditated, and it's the law clerk or whoever failed to catch the fact that should have been the word, they used the word intentionally rather than premeditated. So there's an error.
Well, to criticize the trial judge for attempting to faithfully follow what a higher court has said, she can't say that's simply a typo, and I disagree with it.
I think she could say that if you look at the other statutory reference, 1105 is to the premeditated murder statute. The trial court essentially imputed to the Arizona Supreme Court a mistake that they cited the premeditated murder statute when they meant the intentional murder statute. And so I think, again, it creates, in our view, bizarre interpretation of Arizona law where criminals who intend to kill can only be charged with second-degree murder, but those who intend to injure can be charged with first-degree felony murder. So I think the trial court could have, with all respect to the Arizona Supreme Court, say, look, we don't construe Arizona Supreme Court decisions to lead to nonsensical results. We construe them to lead to sensible results.
When you say the intentional murder statute as opposed to the premeditated murder statute,
Right.
Which statute are you
First
talking
and second-degree murder. First-degree murder is premeditated, as I understand Arizona law. Second-degree murder is intentional murder.
about? Okay, so that's why you reference second degree.
Yes. If I could turn to Judge Gould's point about lesser sanctions, that lies at the heart of the problem here. Faced with a smorgasbord of different dispositions in this case, the trial court selected the most extreme sanction possible, throwing out a premeditated throwing out a first-degree murder indictment. There were obviously other options. For example, at page 27 of the 28-page order, the trial court says, well, we could have disqualified the trial team and allowed the indictment to move forward. But the trial court never explains why she rejected that option, other than to say, well, there may have been some delay. The Maricopa County Attorney's Office has 300 attorneys. It would have been a simple matter to recuse the two trial attorneys, refer them to the bar, do whatever needs to be done, and do that instead of dismissing a first-degree murder indictment. The point to be made here is that Ms. Everly had a very strong interest in seeing the alleged murderer of her 5-year-old child brought to justice. And the trial court didn't say, well, I know that's an important interest, but it's outweighed by other factors. The trial court simply ignored that. And that's why we're asking this court to
If the trial court had said, Ms. Everly, as the victim, has interest here, but the interest of the defendant in being tried one time, if possible, and properly so at that, outweigh, that would have resolved your concern?
We certainly have a much different case. This is, we think, an easy case for reversal because when you have a standard that requires a finding that the interests of justice support throwing out a first-degree murder indictment, there should be at least some analysis, and we would hope careful and supported analysis to support selecting that most extreme sanction. But here you have no analysis at all. So we would ask for a remand back to the trial court to say, look, Arizona victims have constitutional rights that are at stake here. They have a right to fairness. They have the right to have decisions like Stiers interpreted correctly. They have a right to rules of criminal procedure that are construed to protect their interests. None of those are even mentioned in the trial court's decision, let alone, rejected or something as you're suggesting. And so unless there are further pressing questions, I anticipate we'll be hearing some disagreement from the other side. I'd like to serve rebuttal time for both of us to address those concerns.
No, thank you, counsel.
Thank you.
May it please the court, good afternoon. My name is Treasure Van Drummel. I and my colleague Michael Terabile represent Mr. Martinson. I want to start out where the court started out because I had some concerns. I agree with Mr. Grant's opening brief that this is not the place to litigate the propriety of Stiers. He said it in his open brief. He said it in his answering brief on cross appeal. Both of us agree that the trial court's clear and unambiguous order of August 9th, 2011 is, in fact, the key to finding intentional prosecutorial misconduct in this case. Lawyers, of course, cannot intentionally violate court orders just because they think the judge is wrong. I have concerns about my colleagues on the left trying to resurrect a right to appeal the Stiers order that was never taken in August of 2011. When we appeared before this court on special action, the court noted that the Stiers issue was not before them at that time either. And so I have concerns about that. I think it is procedurally improper at this point to try to litigate, and I haven't litigated in the briefs because of Mr. Grant's concession that I agreed with.
But counsel, I mean, isn't Stiers at the heart of this issue? I mean, the very order that was entered by the court was based on Stiers. Most of the order regarding the finding of prosecutorial misconduct is based on violations that were determined by the trial judge of Stiers. How can you say that Stiers isn't before us now? Of course it's before us.
Well, because the Stiers decision was the underpinning of the trial court's order. We're here to determine one question, and that is whether or not prosecutorial misconduct took place to intentionally deprive the defendant of a fair trial. And so, in our view, it is the court's order, right or wrong, that governs the prosecutorial misconduct inquiry. Certainly, as a lawyer, I can't violate a court order because I think they're wrong.
I think that I'm certainly with you in terms of what you just said. The court's order, you have to respect the order, and you can't intentionally violate a court order. But at some point, if you're going to find such egregious misconduct as to dismiss a case with prejudice, Stiers has to come into play, doesn't it? Whether it's, if in fact, as the state contends, the trial court made an error as a matter of law regarding its construction of Stiers, then this court wouldn't be able to simply ignore that fact if it were true, would we?
I think, given the claim that's presented to you, I think the answer is yes. If a judge improperly precludes a self-defense and the defense lawyer ignores it and puts it on anyway, yes, that's misconduct. That's the difference between misconduct and the order. Her order said no evidence of intentional killing or intent to kill. That's what her order said. And I just want to make sure the panel is clear. My colleagues are talking about evidence that was precluded. There was no evidence that was precluded. Everything that you see in the briefs is all of the evidence in this case.
Let me ask you a question along those lines then. I understand your argument. The state contends that it's the same evidence to prove the child abuse as the intent to kill. In other words, I took that to mean giving the drugs to the child if in fact that happened under their theory of the case. What's your response to that? If it's the same evidence, then what would be the misconduct? Or were there categorically different pieces of evidence that shouldn't have come in under intent to kill?
Both.
Okay.
The brunt of the motive evidence concerns a relationship that my client had with the child's mother 4 years prior to the child's demise. 4 years prior, not in the interim, 4 years prior. That evidence, the judge said, you can introduce it as evidence of motive, but make clear it's not motive to kill. It's motive to injure, because that's what child abuse requires. Responding to your second question, what other evidence came in with respect to that, it focuses primarily on two aspects. The judge allowed the state to introduce garbage bags that was found in my client's laundry room. When asked why at the bench over the defense objection, the state said the jury's entitled to know what the police found at the search. Okay, so if you look at that piece of evidence and her introduction of those bags, it doesn't look like misconduct. But when you see how she used it in direct violation of the court order, that's what makes it misconduct. Piece by piece, she called witnesses to testify that maybe the child's DNA was on it, maybe it wasn't. Maybe the child's hairs were on it, maybe they weren't. Garbage bags is what I'm referring to. And then she called the medical examiner to say what's an alternative cause of death, and he said suffering with smothering or suffocation with a garbage bag. And then they put on the detective's interrogation where she said it over and over. Did you put a bag over his head? Did you? And so the detective's interrogation is is the masterpiece in this case, because that's why the state didn't have to explain anything in its arguments to the jury. It was all put in context by that interrogation.
Counsel, let me ask you a question. I'm looking at the statute, the child abuse statute, 133623, subsection A. And in describing the crime of child abuse, it says, under circumstances likely to produce death or serious physical injury, any person who causes a child to suffer physical injury.
Yes.
Now, what do you make of that language in terms of evidence regarding intent to injure or intent to kill?
I believe that evidence supporting an intent to injure, that is the mens rea for the statute, is admissible. Intent to kill is not.
And why does the statute say under circumstances likely to produce death or serious physical injury?
Because that, as Payne explained, that's just the surrounding circumstance that the child abuse took place.
But you're saying that intent to kill evidence should not come in because of Stiers?
Yes.
But what if we don't agree with that interpretation of Stiers?
Well, that's why I started out my argument like I did, Your Honor.
I understand.
You know, it seems to me that the state can't resurrect a lost right to appeal. We're, as lawyers, we're either bound to follow court orders or we're not.
Well,
And
I certainly join in agreeing with everything that you and Judge Gould have said, and others may say that lawyers are supposed to follow court orders. But part of looking at whether this most stringent sanction of dismissal with prejudice is applicable is to look at prejudice.
I agree.
And if all of this evidence was supposed to have come in anyway,
No.
where's the prejudice?
No, like the judge said, it's how you use the evidence that is going to dictate these proceedings. Her precise words were, I'm going to make it clear. If there's a pattern and practice of using this type of evidence with the lingering suggestion that's so heavy that even though it's not stated on the record, it's clear by the atmosphere in the courtroom that it's an implication, it's an intent to kill, then there's going to be a problem.
But
How do we square
Go
that
ahead.
with the fact that then later, when there were multiple requests for mistrial based on alleged violations of that directive, the judge denied them?
I'm glad that you asked that. A couple things on that. First of all, we weren't getting entire transcripts of the record. We were taking notes as things were happening in the trial, and I was filing the motions. So it was not, as Mr. Grant said, the same motion all the time. It kept getting bigger and bigger and bigger. It started with the opening statement, and then it just got bigger as the things kept coming at us. I'd also note, and I know that you've read Jorgensen, so I don't mean to be condescending, but the Supreme Court made clear that the erroneous denials of the mistrial doesn't govern the inquiry with respect to prosecutorial misconduct, because a lot of times the judges can't see the overarching picture, and that's exactly what happened here. Things that were seemingly innocuous didn't come to light until the whole thing had ended, and then she finally, once I presented the final motion to dismiss based on prosecutorial misconduct and included portions of the record, and that's why her citations to the record don't match up with the record on appeal, because she only had little portions of the record. That's why the light finally went on to the judge and she could see what we were talking about.
Counsel, what do you make of the language in State v. Milkey, the companion case to this case, that says this holding has no effect, the holding on Stiers has no effect on the use of child abuse as a predicate offense for felony murder?
Absolutely. Absolutely. Just like Stiers said, if you intend to physically injure and you physically injure and the child dies from that injury, it is straight up child abuse and felony murder.
I guess maybe we're reading that statement differently. When I read that statement, the court's saying, by the way, in Stiers, if we want to clarify, you can use child abuse as a predicate felony, and our opinion in Stiers had nothing to limit your use of that predicate offense. In other words, I see that language as simply limiting Stiers to you may not be able to sustain a separate conviction for child abuse if all you have is evidence of intent to kill. You don't read that language that way?
No, sir, because Stiers starts out with the question. The question posed by the court to itself in Stiers is whether or not the legislature intended the child abuse statute to apply in all circumstance where a child victim is murdered. Their answer was no. And the reason for that is when you have felony murder, child abuse, that is absolutely permissible. When you have an intent to injure and an injury and the child dies from that injury, that's straight up felony murder, child abuse. But
In other words, if there was any doubt before Stiers, after Stiers, your point is that the child abuse statute does not encompass intent to kill.
that is exactly my point, Your Honor. Exactly. That is how Stiers, Justice Martone, interpreted this child abuse statute in 1993.
I thought it was Justice Mueller,
Oh, you are correct. I'm sorry.
but it doesn't matter, I don't think.
It matters to me.
It may matter to them. But I would take it then that under your interpretation of the statute and Stiers, that Stiers either changed or at least clarified what the statute means.
I believe that it clarified what the statute meant, what the state or the court looked at the legislative intent, as you've read, and analogized it to assault.
It seems, this may be my own naivete, I suppose, but it seems odd to me that in 23 years this hasn't come up before now, of what the Supreme Court meant by some of that language in Stiers. Maybe it does come up in the trial court, and we just don't see it.
Maybe people don't think it's as confusing as my colleagues on the left.
Or as we may.
Counsel, let me read you a statement from State v. Moore. This is 222 Arizona 1, page 13 of paragraph 57. And in that case, the Supreme Court rejected a challenge to a conviction for felony murder where the defendant had argued that under the merger doctrine, felony murder cannot be predicated upon a burglary that is itself based on an intent to murder. And the court said, quote, "It would be anomalous to conclude that first-degree murder occurs if a burglary with an intent to assault results in death, but not if the burglary is based on the more culpable intent to murder." Well, how would you respond to that?
I think the child abuse statute is different. It's different than the burglary statute. The child abuse statute requires an intent to harm. So where there's intent to kill, that's a different mens rea than is in the child abuse statute. I don't know if I answered your question.
Well, I mean, it seems to me that if you can have a predicate felony of a burglary where the intent is to commit murder, as the felony, the purpose of the felony once you've entered the home, that you can have a child abuse where the intent is to injure and you end up killing somebody, so you have the intent to kill. Why wouldn't those two be consistent?
Here's the difference. The burglary statute is entering unlawfully with the intent to commit a theft or felony therein. The felony therein is kind of like a predicate offense. So when the state alleges burglary in circumstances like Moore, the intent to enter with a theft or felony therein, they say the felony therein is murder. And so intent is becomes part and parcel of the burglary statute. You understand? It's like a predicate to the burglary, because burglary is entering unlawfully with the intent to commit a theft or felony therein. So the state takes the position, like they did in Moore, the felony he intended to commit in connection with the burglary is murder. Murder has a mens rea of intent, intentional killing, whereas child abuse does not. Okay, if I could, in the pleadings filed by the state, there's a whole lot of talk about what the judge did, what defense counsel did, and I would hearken the court to the only cases that deal squarely with this issue, which is Poole, Minute, Hughes, Jorgensen, and Milkey versus Mraz. Those are the only ones in Arizona history, because my colleague, Mr. Grant, is absolutely correct. These are rare circumstances that something like this happens. Nowhere in those decisions does it say the court should have considered a less strict sanction. That's because the constitutional right of a defendant to proceed to trial and get a fair trial by the jury he selected in the first instance is paramount. And the court has recognized that in all of those cases. And the double jeopardy clause, once that is found, once intentional misconduct is found, the double jeopardy clause is unconcerned with balancing equities, contrary to what the Victims' Counsel says. There is no balance of equities where the double jeopardy clause is invoked to bar retrial for intentional prosecutorial misconduct. I do agree with Mr. Grant. It is a high standard. It's a high bar to meet. You have to show that the prosecutor engaged in questioning, argument, innuendo for one purpose and one purpose only, and that is to avoid acquittal, to prejudice the jury, and obtain conviction with an absolute indifference to the danger of mistrial or reversal on appeal. That's tough to show in a lot of cases. In this case, it isn't. It was a pattern in practice that started from opening statement and continued all the way through the end of the guilt phase, the penalty phase arguments in front of the jury. The court in Minute, especially, made clear that defense counsel's conduct is not at issue. The defense counsel's failure to object is not the issue. The court has routinely gotten us to focus on the prosecutor's conduct. That's the only question in this case. What was her conduct? What was her intent? What prejudice or result did it have? In this case, it was clearly prejudicial, and the record belies any claim otherwise because we have actual juror testimony. So some of the jurors absolutely echoed the prosecutor's innuendo, which is born directly from the interrogation that was admitted when she didn't redact it following the court's order. And remember, the court's order was issued on the second day of trial, the morning before anything even started. We did opening statements, one witness testified, and then we came in the next morning.
Let me pose a scenario to you, counsel. I mean this in all good faith. I want to hear your answer on it. This idea about drawing this line between evidence that's meant to show intent to injure versus intent to kill. If you strike someone very hard with a closed fist, that could be an intent to injure or an intent to kill. How does a trial court, try to discern whether that type of evidence is really evidence of intent to kill versus intent to injure? I mean, in a sense, death is the ultimate form of injury, right? And so I'm wondering, and then I'm also wondering, what's to stop a defendant at some point from saying, all these things I did, and I know this isn't the case here, this is a hypothetical, none of that was meant to kill. I just meant to injure. And therefore, Judge, you should exclude all this evidence because none of it really is meant to show an intent to kill.
It is fact-specific. Clearly in Stiers, we have Christopher Milkey being shot in the head. There's no question there that's an intent to kill. In this case, there's also no question, so we don't even need to reach, Your Honors.
You really couldn't. A separate child abuse conviction where you take a young child and shoot him back in the head execution style 3 times, I think it would be hard to argue that that was simply child abuse. But here you have something different. Now, you talked about some of the bags that were used in this case. Setting aside, I understand what the pathologist said and gave some conclusory testimony. But in terms of the state's use of that evidence, it's sort of the same conundrum. Using those bags could have been done with an intent to injure, or it could have been done with an intent to kill. Why would it be error to allow that in, or posing it from a different direction? How is the state supposed to separate this evidence that could be shown to prove an intent to injure if it may have a connotation also of an intent to kill?
Well, I'm not a prosecutor, so I'm not sure I could answer that, but what I can tell you is this. When you put a bag over a child's head and keep it there for any length of time, that is not an intent to injure. What happens is, just like Dr. Who says,
But that could be said about any of the evidence in this case. If, in fact, these very strong drugs were given to the child, does a parent do that simply to hurt the child? And any of this evidence could be intent to kill or intent to injure. I'm not sure why it's misconduct to present evidence that could be both.
Because-
Unless there was something, as in the Steyer situation, which clearly is intent to kill. I'm just asking you that.
I understand, and it's our position that use of the garbage bag and getting Dr. Who to say he could have been smothered or suffocated, that's clearly intent to kill. Also, the state's argument that he gave his kid a drug and then watched him linger and die, that's an intent to kill. It is, the prosecutor is obligated to make sure the jury doesn't mistake what is being tried in front of them. And here the jury got the prosecutor's picture loud and clear. They believed that it was an intentional homicide case. And it wasn't an accident, Your Honor. It was because of all of the evidence and how the evidence was marshaled. And so it's not what the evidence is, it's how the state intended to use it and did use it. That's what causes the problem. If you're asking me, well, how could they have got the garbage bags in if it wasn't an intent to kill? I don't think that they're relevant. They shouldn't have come in at all.
Let me flip the question for you. How can child abuse then be used as a predicate felony for felony murder?
There's a whole lot of cases on that. Essentially, by
its very nature, if it's a predicate felony to felony murder, then you're going to be presenting evidence of child abuse that ended up in a child dying, right?
Mm-hmm. Yes.
So how do you present that evidence where you simply say that all this evidence, ladies and gentlemen, is just an intent to injure, and by the way, the child died as a result of it. Is that how they're supposed to present it?
It's an unintended death. They have to present evidence of an intent to injure. For example, let's talk about Velasquez, punching the child in the abdomen, or tripping the child as they're walking so they fall and hit their head a whole bunch of times. The defendants are laughing. They think it's funny. The child ultimately develops brain trauma and dies. So that's how you do it. There was no intent to kill, but it was just mean-spirited stupidity that intentionally caused physical injury. And remember, State versus Bennett requires the causal nexus. He has to die from that injury. So it's not merely a fact of committing physical injury and then the child dies. There's a nexus in there, and Stiers brings it out as well. He has to die from that injury in order for it to be felony murder child abuse.
That's what happened here, right? There was child abuse alleged as a predicate felony, and the child died.
Yes. The state alleged that the defendant gave the child a drug, and the child died. That's how the case should have been tried. That's exactly how the case should have been tried, but it wasn't. There's all this stuff about garbage bags and lingering. How many times did the court tell them, you cannot use that? There is no facts and evidence to suggest that this child lingered. And they did it anyway. They just ignored the court order, which is why I keep going back to the real reason we're here, and that is the instances of misconduct based upon her questions, based upon the answer, her intent, and her arguments to the jury.
When you say the child lingering, I'd have to look at that portion of the record, but what does that have to do with the intent to kill? Is that describing what happened to the child after these acts were conducted?
There was no evidence of that, Judge.
Okay.
None. That was the prosecutor's arguments to the jury, is that the child lingered and the defendant didn't call 911 to get help.
But what does that have to do with the intent to kill versus the intent to injure?
Because she's saying the defendant just stood there and watched him and he died. And there was no evidence of any of that. There was no evidence that he showed any symptoms at all, much less the defendant saw symptoms and then failed to call 911. The prosecutor twisted it into intentional murder by telling the jury he just watched. He watched his child linger and die and didn't call 911. And that's exactly what the detective said during the interrogation. So it wasn't much of a leap for the jury. The detective said, you must have seen him. You must have seen him suffering, etc.
All right, so how were they supposed to argue felony murder then?
They were supposed to argue that the defendant gave him a drug that is not prescribed for children, and the child died from that drug. That's what they were supposed to argue. That's what the case was all about. Not garbage bags, not lingering, just the child died from that drug. That's how it was supposed to be argued if she had followed the judge's order, which didn't happen. I'm going to.
I have a short procedural question. You referenced earlier, and this, I'm going back to Stiers again.
Okay.
And what you've stated pretty clearly, your view that it's not really before us, but I wanted to explore, I think I heard you say words to the effect that the state did not or failed to appeal back when they might have, and so I think I'm getting the impression that you don't feel like they can argue it now for us to interpret Stiers in some way that helps them. What should the state have done procedurally? How would they have appealed that?
Filed a special action.
Okay.
Filed a
that would
special
be the
action.
only way, right?
That would be the only way, yes.
All right.
Minute, Jorgensen, Milky versus Mraz, Poole, none of them did what Judge Duncan did in this case by saying, let me consider other alternatives. And that's just because of the double jeopardy clause. My dispute with my colleagues representing the victim lies in the fact that they can't argue the Stiers issue. That is not for them to argue. It is a purely legal issue that doesn't affect victims' rights. They have routinely conflated in their pleadings.
And I want to be clear, we've allowed the argument to go forward today, but that doesn't mean we've ruled in their favor.
Okay.
So I want you to understand that.
They've routinely conflated in their pleadings the judge's order in this case, because we argued on October 3rd, 2013, the state's motion to dismiss that this court remanded as to whether or not they could do that or whether or not it was brought in bad faith, and we also litigated the defendant's motion to dismiss. We stood there and litigated both of those motions. Our motion wasn't brought pursuant to Rule 16. Rule 16.6b says that the defense can bring a motion to dismiss an indictment that is insufficient as a matter of law. This indictment was not insufficient as a matter of law. We brought this motion under Poole, Stiers. Okay, so I won't beat that to death. I also wanted to add that with respect to the statutes allowing the victims appear, my colleague, Mr. Cassell, omits mention of the fact that the statute that defines final determination says by the trial court. He focuses on the word ultimate, but he omits the phrase by the trial court. The fact that the legislature knew when they were implementing these statutes that they knew that there's a difference between the trial court and the appellate court level is evident because they defined both. One of them is defined in subsection 4, and the other one is in subsection 10 of 1344-01. And so then the question becomes, well, then how do they get here? How do they get to court? How do they file a notice of appearance? Well, under section 1344-37A, that's the one they relied on to file a notice of appearance in this case. It says the victim has standing to seek an order to bring special action or a notice of appearance in an appellate proceeding seeking to enforce any right or challenge an order denying any right. Well, how do they get there? Here's how. 13-40324 allows the state to appeal an order made after judgment affecting the substantial rights of the states or a victim, but the state can only take an appeal on an order affecting the substantial rights of a victim at the victim's request. So the state has to file an appeal under 40324. Then the victim can come in and file a notice of appearance. That didn't happen in this case. The state appealed the order of dismissal. Its notice of appeal is filed under 40321, which is the dismissal of a case. And so it's our position that Ms. Eberly is neither a victim by definition, and it's not properly before the court because the state did not invoke this court's appellate jurisdiction. And our third position is that she simply has no right to come in and argue substantive rulings by the court, and her position that the judge should have considered her views was made too late, as I've said in the pleading. She was right there when we were arguing it. The judge said, anybody else have anything to say? She said nothing. Then the ruling came out. Then she filed her motion saying, please consider my views. Too late. This court has held many times that not only can victims waive rights based on an untimely request, but so can all the other parties. In Medina versus ADOT, this court said ADOT delayed raising the issue until after the court reached a decision and thus waived it. So those are our claims with respect to the victim's right to appear in this proceeding.
Thank you, counsel.
Thank you.
Is it Mr. Grant? You're going up first?
Thank you, Your Honor. Just a couple of things. First, the court and counsel have focused on the state's appeal. I don't want to disregard anything I presented in the answering brief, but I think I'll just submit that on those arguments rather than dealing with the cross appeal and oral argument. A few comments regarding defense counsel's argument here. The discussion of Stiers and what the state should have done about it. It's important to note that when the Stiers ruling came down, it was after jeopardy had attached. The prospects of filing a special action after a jury has been impaneled and jeopardy had attached, the prospects of getting relief are slim to none. That's why the state didn't take any action at that time. Counsel pointed to the previous special action regarding the filing of the second indictment. That occurred after the case had been, after the verdict had been overturned. By that time, it was too late to do anything about Stiers, and we couldn't do anything because jeopardy had attached in the first place.
You made some comments in your initial argument that were somewhat consistent with Ms. Van Drummel's contention that the interpretation of Stiers is not really what's before us. It's whether the prosecutors violated the court's order, whether that order was correct or incorrect under Stiers. Do you agree with that?
I agree that the state was bound to follow that ruling. My position is that they did.
So even if the court was incorrect about Stiers, you agree that the prosecutors had to follow it, and your contention is they did, and that's what our focus should be on?
Well, based on the questions the other judges have asked, I certainly don't cut off this court from doing what it thinks it might need to do with regarding Stiers, but my position is it was a ruling by the trial court that the prosecutors were obliged to comply with, and that they did. Just a quick correction. I think counsel argued that the trial court ruled, and this is just a small matter, mentioned that the trial court had allowed evidence of what occurred prior to Joshua's birth. I think if you look at item number 265 at page 3 in the index on the record on appeal, it's clear that the trial court excluded all evidence that occurred prior to Joshua's birth regarding the conflict between the two, between Mr. Martinson and Miss Eberly. Also, counsel suggested that what the state's doing is blaming the court and defense. That's not what we're doing at all. I think the things we pointed out are indications that there was no misconduct at all. And as far as concealment, which is what the court dealt with in Minute, the concealment was, it only came forward because of statements that were made in police reports. Those are things that are not available to trial judges generally. And the only way it came to the judge's attention in Minute was that defense counsel, after I believe 2 trials, discovered it and brought it to the court's attention. That was the concealment. Here there's no concealment. The trial court, throughout its ruling, the 28-page ruling, repeatedly makes mention of instances that are in the record when it tells the prosecutors to stop doing these sort of things.
Counsel, you don't disagree with the general proposition that a judge can take a look back at a trial and perhaps see something in the record that they didn't see at the time. I mean, in a motion for new trial, sometimes a judge may have made an evidentiary ruling overruling an objection and seeing that it was error and come back and granted a new trial. I mean, you're not, as a general matter, disagreeing with that.
Correct. I'm agreeing with that.
Judge Duncan could have gone back and looked at that and seen it differently, right?
Sure, but I don't think there was anything to see differently here is my position.
All right.
I think the court was clear throughout what it wanted the trial court, what it wanted the prosecutors to do and not to do. And I don't think anything changed by the time of the end of the trial. Let's see. With regard to the intent to injure, and I'm starting to run out of time here, but let me try and be quick. The trial court recognized at various instances that the state's evidence supported intent to injure. And again, I think it creates that problem that the court has discussed with counsel, both parties. How is the state supposed to present evidence of intent to injure if it also suggests intent to kill? I think the prosecutors tried their best to comply with that, and I think they did.
Well, maybe I was inartful in saying that. I guess I'm putting this child abuse offense in the context of the felony murder statute and asking what evidence would be admitted to prove child abuse under circumstances that could cause death with the intent to injure, and also having the charge of felony murder. I think in that context, that's my concern.
Well, I think the example that counsel gave, the punch to the abdomen, I think that could be interpreted in two ways, an intent to injure or an intent to kill. And I think both would support felony murder, with child abuse as the predicate felony. Lastly, just sort of a conclusion, I think with regards to the high bar regarding dismissals for prosecutorial misconduct, what the court had found here and what the defense argued essentially requires this court to believe that for approximately 7 years, the prosecutors in this case carried out this grand plan to present two different theories but to keep one hidden. I think that stretches credibility quite a bit, that anyone could carry out such a prospect for 7 years. The defense just a moment ago just went back to the opening statement, but if you look at the record, their arguments go all the way back to pretrial rulings.
Is that their argument, or is their argument that the prosecutors didn't agree with the ruling and just decided they were going to get the evidence in no matter what?
I think that's what they're arguing here, but if you look at the briefs and if you look at the record, they're arguing that from the very beginning, even I think as far as filing the indictment, that what the prosecutor had in mind is we're going to go with premeditated murder and we're going to also slip in this evidence regarding intent to kill as well. And I think that just strains credibility. And that's why I mentioned in my reply brief, I believe, in Occam's razor, that the simplest explanation is the correct one. And I think that explanation is just too hard to believe. And I'd like to give the rest of my time to victims' counsel.
Thank you, counsel.
Thank you, Your Honors. Let me turn immediately to the question of whether Stiers is in front of the court. It certainly is in front of the court with regard to the victim's argument. Ms. Van Drummel said the issue hasn't been briefed. If you look at pages 36 to 38 of their response brief to our brief, they briefed Stiers. So you've got the arguments in front of you. Ms. Eberle has argued that her right to fairness protected in the Arizona Constitution is violated. And of course, if the trial court made a manifestly legal incorrect decision, her right to fairness would be violated by having a trial move forward on a legal error. Moreover, the interests of justice are in front of the court. That's the Rule 16.6 balancing test. Well, the interests of justice are not served if this court validates an incorrect legal determination by the trial court and then throws out a first-degree murder indictment and prevents the people of the state of Arizona from passing on the validity of that indictment. The court has pointed out throughout its questions that the idea that intent to kill is different than intent to injure is something that is not policeable, not enforceable, and led to the confusion in the court below. And I cited both in my brief and in oral argument today the curious, I would actually use the strong term bizarre effect that the defense position, if upheld by this court, would create in Arizona law. Defendants who intend to kill children can only be charged with second-degree murder, but those who intend to injure children can be charged with first-degree murder.
It almost sounds like you're suggesting that if that the logical outcropping of this decision, such a decision, could be that a defendant could defend by saying, no, I intended.
That's, I think, exactly one of the loopholes that would be created and prevent, they may not be arguing that, but the effect of their position is that now defendants have a loophole under Arizona law and can escape first-degree murder convictions by simply raising a reasonable doubt that they intended to kill a child rather than injure the child. I don't think you should attribute...
Why would a defendant do that? I don't know about that.
Well, the defendant would say, I intended to kill the child, and therefore, under the trial court's ruling that they're defending here, I can't be charged with felony murder. So you can't get me on first-degree murder, you have to get me on second.
I think I understand that as a theoretical issue, but not maybe as a practical issue. But I understand what you're saying.
All right. Let me just turn then, if I can have just an extra minute or so. I think defense had an extra couple of minutes.
We'll give you an extra minute.
A lawyer's minute here. I'll try to be as quick as I can.
Be productive. Hold on one second. We need to reset the clock. Is that okay?
You're in charge.
All right. Thank you very much for your courtesy on that point. Just one last point. Ms. Van Drummel said that balancing of interests is not involved, that you're required to affirm the most severe sanction. Rule 16.6 says the default on a dismissal of an indictment is dismissal without prejudice, naturally enough. It is only when there are findings that support the interests of justice requiring dismissal with prejudice that you affirm a dismissal with prejudice.
I think her point is that this is not a 16.6 issue. This is a double jeopardy issue.
Right, and you don't have to look any further. Here's page 1 of the 28-page order we're looking at. And when you flip to page 2, you will see in bold writing prosecutorial misconduct and Rule 16, the legal standard. That's subsection A. And then subsection B again references Rule 16. Rule 16.
But we may not be bound by that.
Well, the point is, my point is that the trial court certainly thought that her finding rested on Rule 16. It's the first bold-faced heading in the opinion. And so when you look then at what the trial court was doing, it was interpreting Rule 16, specifically 16.6, without regard to even a single sentence discussing the victim's interest.
What about the very last paragraph? Here, the misconduct is so egregious that the double jeopardy clause protects the defendant from multiple attempts. I think you're reading a lot into a heading that's not consistent with the judge's actual conclusion.
Well, she certainly alludes to double jeopardy issues, but double jeopardy issues she then pours into Rule 16. And to the it's odd to me that, as I say, the very first substantive heading in the opinion refers directly to Rule 16 if this is a double jeopardy case. The double jeopardy argument in any event would also require a balancing of interests. Much of double jeopardy law requires the court to look at.
What's the citation for that proposition?
Looking at the interests.
If it's based on double jeopardy, what's the authority for the proposition that balancing tests apply there?
So it would depend on the kind of the case that I'm thinking of is the U.S. Supreme Court's case where it talks about what happens when jurors are potentially bribed or something like that. There may be circumstances in which the defendant's interests and society's interests have to be balanced. If I could have leave to submit a supplemental pleading on that, it wouldn't be a lengthy pleading, just a paragraph. I could direct your court's attention to the authority that I'm thinking of. It's not cited in our brief because that wasn't an issue that I saw being raised in the defense brief.
Let us think about that, okay?
All right.
All right. Don't file anything unless we give an order to file it. Fair
All
enough?
right. I'll certainly save time until I hear a request, but I want to make Ms. Eberly views this as a very, very serious matter and, of course, would be willing to spend whatever time was necessary to present her arguments to the court.
Fair enough. You know, Ms. Van Drummel, I think I gave more than an extra minute. Would you like an additional minute to address?
New York minute.
All right. Any objection from the panel?
I don't know, a New York minute? How about a minute?
We don't get to pick these panels, Ms. Van Drummel, that we serve on. Let's one more minute.
I only want to say this. I can understand how it could be confusing to somebody who wasn't there. And when I say it, I mean the judge's 28-page dismissal order. And that's because, like I said, she did it in tandem. Like, the headings talk about both prosecutorial misconduct, my motion, as well as bad faith under Rule 16A, which was the state's motion. That's why the headings read like that. If you notice, she talks about prosecutorial vindictiveness. Vindictiveness goes to motive. This Poole claim has nothing to do with motive. Poole told us very carefully, you are not to consider the prosecutor's motive. Don't slip there, they said. They said only consider the prosecutor's intent. When she talks about motive and things like that, it's in support of her denial of the state's motion to dismiss without prejudice. That's the only thing I wanted to clarify. She does that all the way through her order. Thank you so much.
You bet. Thank you, counsel. We will take this matter up and we'll issue a written decision in due course. We appreciate your arguments today. Court's in recess.